Greetings and welcome to Massage Therapy, Laws and Rules. What I appreciate most about our law is that Arkansas was one of the first states to regulate massage in 1951. That's over 70 years ago. Not only does the law tell you what is and is not permitted, but if you read and can listen carefully to the law, it can tell you a story of our past. I encourage you to contemplate and stay updated on the law. It is ever changing and evolving to adapt to our profession. Think about how certain parts of the law must have come into existence. An overview of the Arkansas legislature. The Arkansas General Assembly is the legislative branch, or the state legislature, of the Arkansas government. All bills or laws are introduced and debated here. The legislature is bicameral, meaning it has two chambers. The upper chamber is the Arkansas Senate. It consists of 35 members, and the lower chamber is the Arkansas House of Representatives with 100 members. Regular sessions of the General Assembly convene on the second Monday in January of odd-numbered years. So for this decade, that would be in 2021, 2023, 2025, 2027, and 2029, and so on. Fiscal sessions of the Arkansas General Assembly convene on the second Monday in February of even-numbered years. So for this decade, that would have been in 2020, 2022, 2024, 2026, 2028, and etc. Bills originating in the Senate begin with SB and the number 1, and in the House, bills originating there begin with HB and the number 1001. Adjourn sine die is Latin for without a day, and adjourn sine die is generally the last official day of the legislative session. Most bills will become law 90 days following adjourn sine die, or will have an emergency clause that puts them into effect immediately after the governor signs. Appropriations take effect on the first day of the upcoming fiscal year. A history of Arkansas massage therapy law. As we stated in the icebreakers, Arkansas became one of the first states in the Union to regulate the massage therapy profession. Only Ohio in 1915, Florida in 1943, Hawaii, which was still a territory in 1947, and Arkansas and Oregon in 1951 had laws in effect at this time. The AMTA, formerly known as AAMM, was founded in 1943 in Chicago. Their second annual national convention opened in 1947. One Arkansan was elected to their board of directors, May Stover. On August 5th, 1949, the fourth national convention of AMTA, at the time AAMM, opened in Hot Springs. The Arkansas chapter was granted their charter, with May Stover Hughes accepting. Fellow Arkansan J.E. Dude Aldrich gave a lecture, and May Stover Hughes gave a humorous demonstration of the rights and wrongs of massage business. The Arkansas chapter had a charter signing on October 23, 1949, at the home of Aldrich in Little Rock, Arkansas, with 10 of 14 members present. Officers for that year were May, elected as president, J.B. McAlney as vice president, and J.E. Dude Aldrich as secretary-treasurer. A meeting of this chapter was also held on May 21st of 1950. During the 1950s, legislation became more important to the AMTA. Again, at the time they were the AAMM, as the desire to upgrade the profession was strong. The Registration Act became a popular act for charters to pursue at their state level. The purpose of these registration acts were to require registration and licensing of all massage operators within a given state in which it would become law. In August of 1950, at their annual national convention, the, quote, Massage Registration Act was unanimously adopted by the AAMM, and members were urged to get the bill passed through legislatures in their home states. J.E. Julian E. Dude Aldrich was elected third vice president of the officers that year, and May Stovers as the director. In 1951, all officers were re-elected in the Arkansas chapter of AAMM. They were having trouble, however, enforcing their Massage Registration Act. A test case had been taken to court to prove that employees in the government bathhouses had to register as well as those in private businesses. This is the Arkansas Supreme Court case Ladwig versus the Arlington Hotel Company, around 1956. Aldrich was appointed to the Board of Examiners by the Arkansas governor. Aldrich also found many mistakes in the Arkansas massage therapy Registration Act. They were denied the privilege of drawing monies from the Treasury to pay incurred bills because the act failed to name an appropriation in the maximum total dollars and cents. They had to wait until the legislature met again in 1953 to add amendments retroactively in order to pay their inspectors and to pay other bills. All of this caused great confusion and delays, taking considerable amount of time to correct. The laws and rules, formerly known as the Law and Rules and Regulations, have been changed and amended many times since the 1950s to adapt to our evolving profession. In April of 2015, Governor Asa Hutchinson signed Arkansas Senate Bill 145 into law. This abolished the Arkansas State Board of Massage Therapy and transferred the board's powers, duties, and functions, including rulemaking, licensing, and injunctions, under the Arkansas State Board of Health. Main provisions of the laws went into effect on October 1st, 2015. This was largely an administrative transfer, and on October 27, 2015, the new Massage Therapy Technical Advisory Committee, or MTAC, was sworn in. More recently, Arkansas law has been amended to exclude the tuberculosis TB test as a licensing requirement and has had to adopt law and rule changes to include the apprenticeship programs under the Earn and Learn Act. How to read the law. AR code means it is the law of Arkansas. The symbol is a section mark, or is called a Silcro. In massage therapy, the law starts with the numbers 17, 86, 101. 17 being the title, 86 being the chapter, and 101 being the section. In Arkansas law, 17 is the professions, occupations, and businesses title. 86 is the massage therapist chapter. And under certain sections, the law can also look like this: a lowercase a in parentheses being a subsection, number in parentheses being a subdivision, a capital letter in parentheses being a paragraph, a Roman numeral in parentheses being a subparagraph, and again, letters in lowercase in parentheses being a subparagraph. Legal terms defined. Common terms used throughout the law include et sec, this is Latin for and the following. It denotes a list or series of items that continues the item that was just before. Misdemeanor is a criminal offense considered less serious than a felony. Conviction is the act or process of finding a defendant guilty of their charged offense. Jurisdiction is the power of a court to adjudicate or rule on cases and issue orders. Enjoin is a court that issues an injunction against something. An injunction is a court order that requires a person to do or to cease doing specific actions. Prosecution is to initiate criminal proceedings against a person. Liability is the legal enforceable claim on the assets of a business or property of an individual. Promulgate is to declare, announce, or proclaim. To promulgate also puts into force or into effect. Counsel is either a lawyer giving legal advice or representing someone, or counsel could be the act of providing advice or guidance. Found guilty is proving or finding a person to be guilty of a crime by way of jury or bench trial. A plea of guilty is a criminal defendant's admission of committing the offense they are charged with, and their agreement to waive the right to a trial. Nolo contendere is Latin for I do not wish to contend, meaning no contest. Nolo contendere is accepting the punishments of a guilty plea without admitting guilt. Offense is conduct or actions that violate or are punishable under criminal law. Felony is the most serious class of criminal offenses, generally punishable by imprisonment of more than 1 year, usually served in federal or state penitentiary instead of county jails. Levied is legally ordered seizure or sale of property to satisfy a delinquent debt or a judgment. In lieu means instead of or in place of. Appeal is a challenge to a previous legal determination or ruling directed to a legal power higher than the power ruling on the original determination. Enumerated is the equivalent to mentioned specifically or designated or expressly named or granted. Act is a statutory plan passed by legislature, known as a bill until it is enacted or signed and then it becomes a law. Incurred is to become liable or subject to an obligation. Notarized is an act performed by a notary to certify the authenticity and legality of an act, fact, or document. Deny as a person being barred or rejected to become licensed. Suspend is the privilege of a license temporarily withdrawn for a specific period of time. Probation is a license issued as a disciplinary measure when the licensee is out of compliance with licensing standards. Revoke is the termination of the privilege of the license. Permit is the legal, sometimes a written statement that someone is allowed to do something. Penalty is punishment imposed on a person who has violated the law. Infraction are violations or infringements. Infractions are a criminal offense among the most minor, far less serious than even misdemeanors. Accusation is the formal charging of a person of a crime, either by a prosecuting attorney or by filing charges.